Hi there, I'm Brett Bentley from Bentley Attorneys, and this is our new series called Appealing Opinion, in which I will express my opinion, my legal opinion, on various aspects of the law. I know sometimes the law can be a little bit dry, but hopefully my passion for certain aspects of the law will come across in these videos. So the title of today's first episode is called The Legalities of Electronic Registered Mail. Subtitle: Please, South African Post Office, let us move into the 21st century. This particular episode is based on an article that I wrote in the Attorneys magazine for the Law Society called The Rebus, which appeared in the April 2019 edition, called NCA Section 129(1)A Notice, a Practical Perspective on an Interpretive Challenge. Really juicy title. Now, generally, service of documents or communication in terms of the law is prescribed by legislature. So the legislature sets out how we can communicate and who does this form of communication. So traditionally, in terms of our law, any initiation of legal processes is governed by court rules, and specifically those court rules empower certain statutory entities called sheriffs to serve documents. That sheriff has to serve them in accordance with these rules and then render what is called a return of service. And if they've complied with the rules, that objective return of service of them being an independent third party is taken as proper service. But even service by the sheriff is being affected by developments in terms of improved communications as we move towards more digital world, a more electronic world, and our advances in technology are just increasing by the year. So there's one piece of legislation, one single piece of legislation, which is trying to drag us kicking and screaming into the 21st century. And that particular piece of legislation is called the Electronic Communications and Transmission Act 25 of 2002. So the Electronic Communications Act begins to have effect on the way that we serve documents and even the way that sheriff serves documents. So in 2012, for example, we have the case of CMC Woodworking Machinery in Peter Oudendal Kitchens, and in that case there's some difficulty in serving a document, and the plaintiff applicant goes to court and gets an order that they can serve by substituted service through using Facebook Messenger, which is quite innovative. But in that specific case, or in these type of cases, it requires a specific court order of substituted service. It's not the normal way of serving, but at least the progression is there in terms of developing into the 21st century. So where does registered mail fit in terms of the legislative landscape and statutory compliance? There's been a number of pieces of legislation which use registered mail as almost a precursor to the full-blown litigation. Litigation obviously has a costs implication for the person that it's been instituted against, and there's also certain rights that people have in terms of the pieces of legislation like the National Credit Act that they can avail themselves of. And this is almost to advise these people of their rights before the implementation of litigation. So specifically today I'll be looking at two pieces of legislation, and those two pieces of legislation are the National Credit Act, specifically Section 129(1), and then also the South African Schools Act, Section 41 sub 5. Now, both of those pieces of legislation, Section 129, in the case of a consumer where the credit provider wants to institute action against them, they have to give a notice in terms of this 129 of the intention, and then the consumer has certain rights within 10 days to avail themselves of certain remedies in terms of debt mediation. If they don't do that, then the credit provider is entitled to institute legal action. In terms of the Schools Act, before a school can institute legal action for a public school, that is, can institute legal action for the recovery of public school fees, it has to give a notice in terms of Section 41(5), in which the parent is advised of their rights to apply for an exemption from public school fees. And if they don't do that within 3-month period, then the school has the right to institute an action for the recovery of those public school fees. So you see this whole precursor, give them a last chance before the costs of litigation come into being. But relying on registered mail, that's where the problem has come in, and specifically with Section 129, because there's been a slew of cases on specifics of how one is to do registered mail. So there's been umpteen provincial decisions. There's been a Supreme Court of Appeal decision which went over 100 pages. There's been 2 or 3 constitutional court cases on how to do it. So those credit providers or attorneys acting for credit providers that have to comply with Section 129 have felt very much like the Greek mythological character Sisyphus. For those of you that don't know about Sisyphus, he was a king in Greek mythology that was punished by Zeus, the king of the gods, and he was sent to Hades, to hell, and his punishment was to roll this boulder up the hill, and when he got to the top of the hill, the boulder would roll down and he'd have to go to the bottom and do it again, and he'd have to do this for eternity. Now, as I said, those of us that act for credit providers and also credit providers themselves felt very much like Sisyphus, because just as we had read the latest case on how to do something as simple as sending a piece of registered mail, lo and behold, there was a new case, and we'd have to spend umpteen pages rereading it to get an understanding. Eventually, I think it was in 2012 and 2014, we had 2 constitutional court cases. Those cases were Sabola and another versus Standard Bank in 2012, and Komyana versus Standard Bank in 2014. And between those 2 cases, the boulder seems to have positioned itself at the top of the hill and doesn't seem to be rolling down again. What the Constitutional Court said in these 2 decisions was it took a very pragmatic approach, and it looked at how the whole process of registered mail looked, and it combined this with something that was brought to the court's attention, that there's a report traditionally called a track and trace, which you can obtain from the post office website, where if you put in the registration number of the particular registered letter, you can track the history and you can see whether the necessary notices have been sent to the sender, whether they have collected it, or whether it's been returned to sender. And what the Constitutional Court said was that the recipient of that is given 2 opportunities to collect the registered mail, and if they choose not to after receiving those 2 notices, then that is their issue, because it's very difficult to prove objective delivery or prove actual delivery in terms of registered letters. It would be an onus that would be far too heavy for the credit provider to bear. So we've got this method of delivering physical registered mail, which has now been set out by the Constitutional Court. That said, it is still a cumbersome and time-consuming piece of communication, which, as I said before, belongs in the 20th century along with the fax machine and the telegraph. So how do we bring it into the 21st century? The answer lies with that piece of legislation that I referred to earlier, called the Electronic Communications and Transmission Act. Section 19(4) of the Electronic Transmissions and Communications Act 25 of 22 states, where any law requires or permits a person to send a document or information by registered or certified post or similar service, that requirement is met if an electronic copy of the document or information is sent to the South African Post Office Limited. It is registered by the said post office and sent by that post office to the electronic address provided by the sender. Now, I submit that that particular piece of legislation and that particular section, Section 19 sub 4, creates a statutory obligation on the post office to provide the service, because they've effectively been given a monopoly on this means of service. If they don't comply with this, there's no way that this innovative method, this new 21st century means of delivery, can be implemented. When in 2016, the South African Post Office announced that it was May 2016 that they were launching e-registered mail. Many users of registered mail, including myself, were extremely delighted at the prospect of the compliance with the Electronic Communications Act and bringing us a better, more cost-effective means of delivery. And you must also bear in mind that registered mail, in these cases, all these pages and pages of cases, it became apparent, and I can talk from personal experience, that physical registered mail in large is not collected by the recipient. So this person that is supposed to be afforded this opportunity of using this notice to rectify or to avail themselves of a remedy can't do it because the chances are they don't collect the registered mail. So hence why the importance of electronic registered mail, because as we look at South Africans, more and more, there's virtually not a South African without some means of receiving electronic registered communication, be that by SMS, be that by email, be that by any form of electronic transfer of a message. So when the post office announced this in 2016, I rubbed my hands in glee, and I was on the phone to the South African Post Office to send their people across so that we could implement this technology and avail ourselves of these services. To be quite frank, in my life, very few times have I seen a salesperson as disinterested in their product as these two people from the South African Post Office were in this electronic registered mail. And when you hear how the system worked, you'll understand their lack of interest in promoting it. So when I asked details of the workings of this particular technology, they advised me that what would happen is that we would register an account with them. We would send our document via PDF attached to an email to them. They would then send an email to the recipient. The recipient would then have to come onto their website and open up a box in which would be deposited this email. This is called push technology, and needless to say, it's not very effective, and the uptake of people using this was minimal to nothing. Fast forward to 2019. In the interim, I had another meeting with the post office, and I got pretty much the same story as I did in 2016. But there starts to come onto the scene various private companies that are talking about providing electronic registered mail. The problem being Section 19(4), which says all of this is given to the post office. The post office is the person with the sole rights to implement this service. So in February 2020, just before the COVID-19 lockdown, we received communication from Registered Communications, one of the companies that had been claiming electronic registered mail, and they provided us with a letter from the South African, purportedly from the South African Post Office, copy of which appears on your screen now, reading: the appointment of Digitale Incorporated as SAPO authorized representative 5th of February 2020, to whom it may concern, the South African Post Office SOC Limited, SAPO hereby confirms that Digitale, a contractual joint venture between Zilwale and Registered Communications, is hereby appointed as an authorized representative agent of SAPO. This authorized representative agent status permits Digitale Incorporated to provide technology that enables the distribution of electronic registered post, open brackets, registered email and registered SMS, as per the requirements of the Electronic Communications and Transmissions Act 25 of 2002. Specifically Clause 19 sub 4. Under this appointment, Digitale may appoint additional resellers operating on behalf of Digitale Incorporated to further promote the use of electronic registered post by the South African commercial and or individual consumers. Signed and authorized on this day, the 5th of February 2020, John Nanyani, Acting Group Executive Sales, who warrants that they are duly authorized. Now, I sent an email to Mr. John Nanyani at the email address provided in this letter, asking him to confirm this appointment, to date, which I haven't received a response. There's two issues with this letter that need to be addressed. Firstly, the legitimacy of the appointment. Was it done in accordance with the Post Office legislation that governs it and the legislation that governs parastatals? Is the appointment correctly being done? And then secondly, does it comply with the Electronic Communications Act, which specifically gives that authority to the South African Post Office? Yes, they could perhaps outsource that. And is this form of agency, is it legitimate? And there's a number of questions that need to be addressed. But the entity that should be addressing these issues is the South African Post Office. And to date, they've been completely silent on this whole question of electronic registered mail. And as I said earlier, there is a statutory obligation on the Post Office to provide this service. The Post Office needs to provide us with answers regarding the development of electronic registered mail, and they need to address it themselves. And as a result of this silence, I have advised numerous of our clients to be very guarded in their use of electronic registered mail, particularly the public schools. And why do I say particularly the public schools? Because the period that the public schools has is much larger. And unlike Section 129, which has 10 days, the Schools Act has 3 months, and Section 129(1) has a safety net if there's not proper compliance with the means of delivery. So that safety net sits in Section 130 sub 4 of the National Credit Act, which says if you go to court and the court finds that you haven't complied with Section 129 in a way that the court finds is appropriate and fits with the compliance with the Act, it can order that the proceedings be stayed, that you go away, you comply with your 129 in the way that the court orders, and then you can come back to court and continue with the proceedings. Similar provisions do not apply to the South African Schools Act. There's no safety net in terms of the South African Schools Act. So if somebody raises the question of failure to comply with the Section 41(5), and you get to, let's say, trial, and the court decides that your Section 41(5) was not properly delivered in accordance with the Act, then you lose. You have to start over the process again. You have to do that, and there might even be issues of prescription. So the dangers to public schools are far higher than to general credit providers in terms of Section 129. Again, I reiterate, and I call upon the South African Post Office to step up and to comply with their obligations in terms of Section 194 of the Electronic Communications and Transmissions Act and provide us with electronic registered mail in a workable solution. Thank you. This is the first of my episodes of Appealing Opinion. If you liked it, please give a like button and also subscribe to our channel. Thank you.